Right, you may have noticed that now the Lucy Letby inquiry has started. So I thought what I would do is just give you a very basic overview of how the inquiry is going to operate and what its terms of reference are, but also what was with the scare quotes. Well, actually, it's called the Thirlwall inquiry. Now, it's not uncommon to name inquiries after the person who is the chair of the inquiry, in this case, Lady Justice Thirlwall. You might remember, the Scarman inquiry into the Brixton riots. But this has been done particularly because Lady Thirlwall has said she doesn't think that Lucy Letby, that name should be bandied around for the families. It shouldn't be about her. It's about, the victims and the families. I mean, that's the starting point. I'm not going to get into the, wrongs or rights or the controversies about the case itself. I just want to give you sort of the overview as to how the inquiry is going to work. So, what's the purpose of a public inquiry? It's basically to look into a matter of, public concern. Now, usually, where there's criminal proceedings and potentially an inquiry, the usual rule is that the criminal proceedings take place first, then you have the inquiry. So that's what's happened here. But contrast that with the Grenfell inquiry, where Theresa May said, no, I want the inquiry first. And that's why all the criminal proceedings have been pushed back. And in my previous video, I speculated and said I don't think they'll even start till 2027. And now people are saying they won't be concluded until 2030. So I suppose at least this way, we've had the criminal trials and, they're out of the way. This is a statutory inquiry under the Inquiries Act 2005 and the Inquiry Rules 2006. So that means that they appoint a chair, the chair has a staff. With it being a statutory inquiry, there's a few more powers, like the chair can actually compel people to attend, issue witness summonses, issue orders for the production of evidence, and it can be a contempt not to cooperate with an inquiry. I mean, obviously, if people disappear, as they did, some people in the Grenfell inquiry just skipped the jurisdiction and said, we're not coming back. There wasn't a lot they could do there. They're in public, and the documentation, for the most part, will actually be available to the public, subject to some redactions for sort of privacy, because obviously it's a very sensitive subject. So, for instance, one thing they've said is, they won't release the names of any of the children. There'll be no sort of identifying evidence there. Inquiries are inquisitorial as opposed to adversarial. In a common law system, generally speaking, most things are adversarial. In other words, all the relevant parties, they decide, how they're going to run their case, what witnesses to call, what evidence to put in, subject to, admissibility. But in an inquiry, the same as an inquest, they use the civil law, like they use on the continent, the civil law inquisitorial system. So it's for the chair of the inquiry to decide what evidence is admissible, which witnesses should be called. Of course, people do get a say, and you have what we call core participants. Core participants are people who have a legitimate interest beyond just the sort of general public interest in the inquiry. So that will include the families of the victims, the people who worked at the hospital, the decision makers. And core participants have sort of extra rights in that they can be represented at the inquiry. They can instruct counsel to go along, to ask questions, to make submissions, that sort of thing. But like I say, it's not quite as much of a free-for-all as a normal adversarial process, where effectively, the judge is just the referee. They're going to be held in public, however, they're not going to be televised. And the reason for that is, again, it's the confidentiality aspects of it. If people are giving live evidence, there's always a risk that they might, slip out sort of, somebody's name or something confidential. So the argument there is that, it isn't going to be live streamed. However, at the end of each day, they will release a transcript of the evidence. So it's all going to be, there's a system that they can use that effectively, live transcripts it. And those recordings, those records, they will be made public. Anything else we need to know about that? Who can be called to give evidence? Well, basically anybody that the chair thinks should give evidence. And like I say, the core participants, they will no doubt have already put in, because there's been lots of preliminary hearings about this, they will have actually put in and said, we think you should call this person, we think you should call this person, here's a series of questions that we think should be addressed. And will there be a report? Yes, there will. At the end of it, there will be a report. One thing Lady Thirlwall hasn't yet decided is whether she will do interim reports, because this inquiry it started now, but it's going to go on, and it's going to go on into at least next year. So it might well be that they release the report in stages, a bit like they did with Grenfell, where you had the phase 1 report, which was how did it actually happen? What was the practicalities of how the fire started and how it was addressed. And then the phase 2 was, well, how did this happen in the first place? What's the wider systemic problems? But what are the terms of reference of the inquiry? I've got them here. So what I'll do is I'll go through the terms of reference so you can see what is going to be included and what isn't going to be included in terms of what they can look at. Because I think a lot of people will say, obviously the question is, well, will they be looking at whether Lucy Letby actually did this? And the answer is no. The starting point is that those convictions stand. Now, obviously, there may be issues that come in, and no doubt some of the questions people say, well, hang on, that sort of raises an issue here. So it'll be interesting to see after the inquiry. And no doubt, Letby's lawyers, because as I said, she's now got a new lawyer. The new lawyer, Mark, he's actually only replaced the junior. She's kept her original Silk, the leader in that case. So obviously she must have some confidence in her legal team, but she's now got this new guy on board, and he's preparing the submissions for the CCRC, the Criminal Cases Review Commission. But it may well be that they're keeping an eye on this as well, because this inquiry may throw up sort of avenues and leads that they may wish to pursue. But anyway, what are the terms of reference? I'm going to read these because they are available from the inquiry's website if you actually want to download them yourself. But the inquiry will investigate 3 broad areas. A, the experiences of Countess of Chester Hospital and other relevant NHS services of all the parents of the babies named in the indictment. B, the conduct of those working at Countess of Chester Hospital, including the board, managers, doctors, nurses, midwives, with regards to the actions of Lucy Letby while she was employed there as a neonatal nurse, and subsequently including 1, whether suspicions should have been raised earlier, whether Lucy Letby should have been suspended earlier, and whether the police and other external bodies should have been informed sooner about suspicions about her. 2, the responses to concerns raised about Lucy Letby from those with management responsibilities within the Trust. And 3, whether the Trust's culture, management and governance structures and processes contributed to the failure to protect babies from Lucy Letby. And just to sort of put my own bit in here for a second, we've discussed before about sort of corporate manslaughter and how that is where you can't identify a particular individual at fault, but you can identify that an organisation had systems in place that allowed some things to happen. And therefore the organisation can be prosecuted because the argument being, but for their inadequate systems, this would not have happened. So that's just a little aside, but I do find that interesting that that's a term of reference as to whether there may be subsequent criminal proceedings on the back of this inquiry. The third one, C, the effectiveness of NHS management and governance structures and processes, external scrutiny and professional regulation in keeping babies in hospital safe and well looked after, whether changes are necessary, and if so, what they should be, including how accountability of senior managers should be strengthened. This section will include a consideration of NHS culture. Again, this is in the same way that coroners in inquests, they can do a sort of a report afterwards where they can make recommendations for improving safety afterwards and reducing the risk to life generally. And obviously inquiries can do a similar thing. I mean, the Grenfell inquiry, they've published a huge series of recommendations. I think the most interesting one from there, just to go on a little bit by diversion, is they're saying that they should introduce a fire brigade college to look at the best practice for dealing with things. I noticed there were some firefighters in the comments who were talking about on my video about Grenfell, was saying there used to be effectively a system in place where they could exchange good practice, and that all went out the window. And some people were suggesting that that was one of the problems, that each fire service was on a little frolic of its own in terms of how they dealt with things, and there was no way of sharing information, but also there was a culture of, well, you know, it wasn't invented round here, so, you know, we're going to do it our way, we don't care what other people do. But there's also a non-exhaustive list of questions arising out of the terms of reference. Now, like I said, these are just questions that the inquiry will consider. It's not, you know, that they have to sort of produce a sort of like an exam paper and respond to each one, but this is the sort of general sort of things that they are looking at. But other questions will no doubt arise. So this actually technically isn't part of the terms of reference, though. This is just like a serving suggestion. But they'll look at the experience of all the parents whose babies were named in the indictment of the criminal trial. During their involvement with the hospital and elsewhere, what were the parents of each child told, and by whom, and the condition of their baby? What was being done to treat them? What was the prognosis? How and when were deteriorations, sudden or otherwise, in the baby's conditions explained to them? Where parents raised concerns about the condition and stroke or care of their babies, what was done? What were they told? When were they given access to their baby's medical records? What information were the parents given by the hospital regarding the concerns about Lucy Letby's conduct? And when? And what were they told about this? And what were they told was being done? What were the parents of each child told about the likely cause of death or injuries? When and by whom? Because obviously, you know, a lot of people were initially told, oh, it was just natural causes. And I think that's one of the controversies, is that some of the initial, you know, death certificates and coroner's reports said, well, you know, nothing suspicious here, these things happen, you know, sudden infant death syndrome, and these were poorly babies anyway. And obviously that's changed. But that's obviously, understandably, why that's a key question. Here's an interesting one. What are the views of the parents of each child as to the adequacy of the information they were given? In other words, give us the feedback from the parents. What were, you know, how did you feel about this? Did you feel that you were being told everything? Were you being snubbed? Were you being left in the dark? You know, what was your subjective experience? What was the parents' experience of what we call the patient advice and liaison service? That's, you know, the body that's meant to sort of keep them informed. What are their suggestions for keeping babies safe on a neonatal unit? Now, that's a controversial question, I think, because now, obviously, after sort of tragedies, well, it's not a tragedy, because the definition of a tragedy is it's something that's unavoidable, and this was clearly avoidable. But we do see this where we've had, like, you know, air disasters and things, and, you know, they will ask the families and say, well, what would you do? And there is a controversy there, because people say, well, they're not experts. Yes, obviously they have very strong feelings about this, and we can understand why they're aggrieved and they want to be listened to. But realistically, are they people who can contribute in this way? Of course, some people go off, you know, it's the old Lorenzo's oil story. Some parents, when they've thought there was inadequate medical treatment or was something wrong, they've gone off and, you know, taught themselves to be experts and actually, you know, provided very useful information, and in some cases actually gone on sort of created treatments. But anyway, second part of the questions. B, the conduct of those working at the hospital, including the board, managers, doctors, nurses and midwives, during the period from the arrival of Lucy Letby at the hospital on 4th of January 2012 up to date. So what was known and what should have been known about Letby's previous work as a nurse when she began employment at the hospital? What concerns were raised and when about the conduct of Letby? By whom were they raised and what was done? Should concerns, including about hospital or clinical data, have been raised earlier than they were? When? What should have been done and when? Were existing processes and procedures for raising concerns used, including whistleblowing and the freedom to speak up? Were they adequate? What was the culture at the hospital? To the extent, did it influence the effectiveness of the processes and procedures that we're looking into? Whether the systems, including security systems relating to the monitoring of access to drugs and babies in neonatal units, would have prevented deliberate harm being caused. Although I suppose that would come back to this thing about the keycard evidence, you know, that was inadequate, you know, at the criminal trials where they got that wrong. So I suppose the argument there will be, even if you had all these systems in place, would you actually be able to use them properly? Sorry, that's just me chipping in myself. When was consideration given to reporting Letby to the police? When was she in fact reported to the police, and who reported her to the police? What information about each of the deaths was provided to the coroner? Was the Trust's provision of information to the coroner appropriate? Because like I say, a lot of people have said, well, loads of coroners said these babies just died of natural causes. So, you know, that raises suspicion as to how can somebody be prosecuted when the coroner found that there was nothing suspicious. And this will be one of the questions. Was the coroner told everything that they needed to know to make a proper decision? Did the relationship between clinicians and managers, nurses, midwives and managers, and between medical professionals at the hospital contribute to any failure to protect babies on the neonatal unit from the actions of Letby? How did professional relationships affect the management and governance of the hospital? And just to be me again, have you noticed there that that question implicitly is saying, assuming, you know, it's just working on the assumption that Letby definitely did this? You know, this is one of the interesting things that, I mean, the thing to remember about the law is, and to go off on a little diversion, the law is very binary. There's no room for a verdict or a decision of, we just don't know. So once something gets across the appropriate threshold, I mean, like, you know, in a civil case, balance of probabilities, that might be really finely balanced. Is this person liable or not? But once the claimant gets across the threshold, you know, the 51%, then yes, as far as the law is concerned, that version of events is correct. And it's the same with the criminal trial. Once you get across the so that you are sure standard and there is a conviction, as far as the law is concerned, unless there's any appeals or anything like that, that stands. That is fact. The courts don't really like collateral challenges on decisions, because the idea is it's all consistent. Now, sometimes that is really bad, and we'll come on to this in future videos when we talk about, because I'm sure this story is going to rumble. But in the Birmingham 6 cases, Lord Denning famously, he refused to allow civil proceedings against the police to go ahead, you know, on the grounds that they had tortured the confessions out of them, because he said this would undermine the criminal convictions, because it's a backdoor way of, because they weren't actually appealing the criminal convictions, they were just saying this evidence was tortured out of us. But Denning's argument was, if this is allowed to go, and as a matter of fact we find that yes, this evidence was illegally obtained and isn't accurate and isn't reliable, then that will undermine the criminal proceedings and we'll have an inconsistency. I mean, we have moved along a little bit from that, but not too much. So it's like I say, the thing to remember is this inquiry is starting on the basis that Letby is guilty. What was the board's involvement in the way concerns about Letby were dealt with by the hospital? You know, was reputation management, all that sort of thing. And what was the board's oversight of clinical and corporate governance? How was Letby managed once concerns were raised about her? I mean, what did they actually do? Did they start to manage her? Did they put other people on with her? Did they just scrutinise the records? Or was she just left pretty much, well, you know, here's somebody we've got suspicions about, but, you know, at the moment we can't really do anything about it, so let her carry on. Was Letby reported to the, pardon me, the Nursing and Midwifery Council? If so, when? What information, if any, was provided to the council, or the Royal Colleges of Nursing, or any other external scrutiny body? Because, of course, you know, in the same way that we're governed by the Bar Council and the Bar Standards Board, medical professions have their own regulators and bodies that, you know, are supposed to take an interest in this. But what was done by those bodies to whom the actions were reported? Did anything happen as a result, and if so, what? What information, if any, was provided to the General Medical Council? What information was requested by the General Medical Council? What was the result of any referral to the GMC? And here's an interesting one. What happened to those who raised concerns about Letby? Because again, you know, this will be a sort of an interesting thing, as, you know, was there a culture of cover-up and conspiracy? You know, because we've heard this before where whistleblowers, I mean, this is why we have sort of theoretical protection for whistleblowers in law now. Because, yeah, they do suffer consequences. You know, nobody wants anybody who's rocking the boat or drawing attention to people or sort of creating bad publicity. So I think that's a very interesting one. And the final area of questions is the wider NHS. whether recommendations to address culture and governance issues made by previous inquiries into the NHS have actually been implemented into wider NHS practice, and if so, to what effect? In other words, because this isn't the first one. We've had Beverley Allerton, for instance. Did we learn any lessons from those? Or did the NHS learn any lessons from those? And have they implemented those lessons? Or is it just going to be, in another 10 years, we're going to have another one of these, and people saying, oh, well, we should have learned from the Letby scenario. What concerns are there about the effectiveness of the current culture, governance, management structures and processes, regulation and other external scrutiny in keeping babies in hospital safe and ensuring the quality of their care? What further changes, if any, should be made to current structures, culture or professional regulation to improve the quality of care and the safety of babies? How should accountability of senior managers be strengthened? This is this whole thing about, we've spoken about the Swiss cheese model and how difficult it is to sort of apportion blame and responsibility in full, where you've got hugely complex systems with lots of people involved who all make individual decisions, any one of which might have been reasonable in the circumstances, but when they all add up in a line, they allow things like this to happen. It's like most sort of disasters and things that go wrong. They're very rarely just one single cause. It's usually a series of little factors that just all happen to line up. So that's something we'll be looking at. And finally, would any concerns with conduct of the board, managers, doctors, nurses, midwives, etc. at the hospital have been addressed through changes in NHS culture, management and governance structures and professional regulation? In other words, should there be a big systemic review of this? And, will that, is this just a sort of one-off that's, nothing could have prevented and it was very isolated, or is there a sort of wider problem in the NHS that allows this to happen? So there you go. Like I say, that's just a very objective, hopefully neutral, about my little chipping in bits, explanation of how the inquiry is going to work. Like I say, the phase one is kicking off now, so there'll be lots of preliminary stuff. And like I say, they will be releasing transcripts at the end of the day, which no doubt will be reported in the press. But you will be able to access those transcripts through the inquiry's website. And I always think if you are following this, don't take anybody else's interpretation, including mine, obviously, because I am only summarising this. And so often the devil is in the detail. And even if you're trying to be objective and neutral, by definition, you're always going to put your own spin on things, even if it's just what you think is important enough to report. I'm not going to read every single transcript out. And the excellent channel Crime Scene to Courtroom, who I really, really like, because I've got a bit of an interest in the Rettendon case for various reasons. But he usually does really, really good things on this. He will read through the transcripts if you want that level of detail. So a little shout out to Crime Scene to Courtroom there. But yeah, I will follow this, and I know Dan is going to do something about this in terms of the sort of wider implications, because miscarriages of justice do happen. We have to acknowledge this. I mean, there's been some terrible miscarriages of justice in the past. I'm not suggesting that this was. I honestly don't know. I mean, my view always is, a jury sat through everything, appeared to pay attention. I trust juries, they tend to do it. And then, obviously we've seen issues about the evidence and stuff like that, but she had a defence team who could have run it. And I know there've been challenges about the defence team, and maybe, things will change in the future. So yeah, we'll probably speculate and get into sort of, more wider issues about this. But in this particular instance, I just wanted to explain to you what the parameters of the inquiry are, what it can do, what it can't do, what it is looking at, and also what it's not looking at, because I think that's one major thing where people will say, well, why is it not looking at whether or not she actually did it? But there you go. As always, hope you found that vaguely useful, vaguely informative. I should imagine it's reasonably accurate, because I actually printed off some notes, including the actual terms of the inquiry there. But yeah, I'll follow this closely, and like I say, Dan is going to do a sort of a supplementary video looking at the sort of wider issues here. So if that's ready, we'll put a link in the description.